going to get started. We waited about 5 extra minutes for everybody to get off the shuttle and come up, but we're going to get started. And of course, people will start filing in, but we're going to make it kind of casual, so we're sitting, if you don't mind. Okay, hopefully you've already read all of these opinions backwards and forwards. You know them by heart. Nothing that we're going to be saying today is brand new. But in any event, if you guys have missed a few, we've got them covered here. We're just giving you the snapshots of what we think are the relevant parts of these cases. And then you will do with them what you wish. You'll use them in the way that you find most effective. Certainly, these are our interpretations of these cases, and you as practitioners could see them differently, hopefully will see them differently, and will use them as differently as you can.
Right,
oh,
stop the clicker.
I did all this. PowerPoint didn't even. Okay, here we go.
Alrighty, so this, the first case, of course, is a fun one out of Downing's courtroom in Department 407. It's LADL just came out. We've got firearms basically in the closet, and they belong to Dad. Mom is in the count for failure to protect, and I think you're gonna have to, we get the storage cases, and what Downing got in trouble for on this particular case is that she found, she kept Mother in the petition for failure to protect, even though Mom had kicked Dad out of the home. She said he is no longer welcome into the home. Dad's visits were monitored. Mom was very clear in the jurisdiction disposition report that she was going to be protective, and that she felt that she had alleviated the risk of harm to the child. These weapons were stored in a not smart way. It was not safe, the storage, the manner of storage. So, and it's important to kind of, if you're going to read this case, because there's also another case out there called Yolanda L., and they touch on the storage of firearms issues. Where Downing got in trouble was that she found that Mom posed a continued risk of harm to the child because Mom was still like monitoring visits with Dad, and Downing felt that Mom's view, and I can totally hear Downing saying this because I was in the courtroom, but she felt that Mom had a quote-unquote lackadaisical view to the harm that Dad's actions had presented. And the Court of Appeal did not agree. The Court of Appeal held that Mother had removed the risk of harm by kicking Dad out. The child was no longer in Father's custody. Dad also expressed remorse himself. He said the next time either I won't own a gun or I will store it properly. So Dad had also indicated that he had learned his lesson. But Downing still felt like that wasn't good enough, and she still kept Mom in the count for failure to protect.
Okay, so this next case, In Re EA, it deals with a nice mashup of issues. I think all of us can relate to the circumstances regarding this case. Very quickly, one of the greatest things that we wish for every day happened. The Department of Children and Family Services, they submitted a last minute or in their recommendation portion of the jurisdiction disposition report, they asked for the petition to be dismissed. That's what we want. Okay, but here are the facts. The parents and the children, they're United States citizens, moved the kids to Mexico, where they reside, in deplorable conditions. Not only were they in deplorable conditions, but when DIP picked up the kids, DIP put them in their version of shelter care, and the parents never came back for them. So DIP was like, well, you guys are United States citizens, let's call San Diego. So they contact the agency in the United States, they pick up the kids, and they file a G count. Right? A G count. They're abandoned kids. What about the deplorable conditions? Is that G? No, that's really something else in 300. Okay, nonetheless, They file the G count, and the department asks for the petition to be dismissed because the parents can't be found. They try to do a home study, they try to do a home evaluation, they can't contact them, they can't get drug tests from them. The only information that they know is that the kids were found in deplorable conditions and the parents are long gone. So the department says, well, we don't have any current information. We don't have any current information, so there's no possible way we can have this petition sustained. Okay, but then here comes our favorite part as Parents Council. The Minors Council speaks up and says, wait a second. I just want to say that I'm going to put you all on notice that I'm going to ask for this petition to be conformed to proof, because clearly there's information here that would fall under 300B. So everybody's kind of like looking at Minors Council, fine. We get to the final hearing where the court's going to consider whether or not to take jurisdiction over these kids. Department is still saying, we can't find them, we haven't done the home evaluation. So then Mother's Council says, well, you know, this can't be a G anyway, because grandma here is taking care of the kids. And if you read through 300G, there's all these different clauses under which you can take the kids under jurisdiction. There's abandonment, you're in jail, you can't arrange for care, and then at the very bottom it says there's a relative who's unwilling and unable to care and the parents can't be found. My mother's attorney says that trumps everything else that G stands for, because we have this grandmother who's taking fantastic care of the kids. So this petition is gone. Father's Council is like, yeah. G has these clauses, and the last one applies, so it trumps the fact that these parents abandoned the kids. And the court's like, yeah, I think so. Minors Council's like, wait a second, I want an Allen M hearing. An Allen M hearing? What's an Allen M hearing? Well, this is where the department's asking for the petition to be dismissed, but the Minors Council has a say. So the Minors Council says, no, we need to have this whole thing evaluated, Your Honor. Look at these facts. These kids need to be under the court's jurisdiction. They have the Allen M hearing, and then they get into this back and forth about G again, and whether or not these different clauses within G trump one another, or do they all apply separately? Bottom line, the court says, nope, there's no possible way here. We have no current information. The grandmother's taking perfectly good care of them, and it trumps the fact that the parents abandoned the kids. So I'm dismissing. And as for that other information, where the kids could likely be found jurisdictional under B, no, it was a G. It was a G. They filed a G. I'm looking at a G. There's no G. Done. The Court of Appeals said, no, that's not how you do this. And for our purposes, the whole point of this case is legal reading and statutory interpretation. It sounds so odd that we're talking about this, but the Court of Appeals said, no, we have to highlight this. Punctuation by a semicolon is indicative of a complete thought in one clause, separate from the other clauses of the statute. Additionally, the plain and ordinary meaning of the word or, when used in a statute, is to designate separate disjunctive categories. So our lesson, for not only the court having no clue to do it this way, is that we're reading the statute clause by clause, and unless and until you see an and, where you have the conjunctive, if you see these ors and semicolons, they apply separate and apart from other clauses within the statute. The other takeaway from this is the Allen M hearing. Be aware of that. That's the ace in the minors attorney's back pocket. I represented minors for 4 years. I had it in my back pocket. I used it whenever I wanted to. So remind yourself, you get this recommendation to dismiss the petition. What's the Minors Council going to do? Allen M, are they going to ask to conform to proof? It is all well within the minors attorney's right to raise it, and the court has to review what's in the best interest of these kids. Oh, okay, this is...
Okay. Well, that's how much I remember about the case. And, no, actually, oh, there, I just remembered more. Okay, this is basically a case that deals with 3 statutes. We have 309E3, which says that within 30 days, the social worker shall conduct an investigation to determine who may or may not be a relative to consider for placement. 358B2, another statute cited in the case, indicates that the social worker is obligated to exercise due diligence and find relatives pursuant to the methods described in 309E3. And the case also, of course, has to do with relative placement. Mom's child, SK, was born with methamphetamine in his system. Mom decided soon after his birth to abscond with him, and when they were both found, the child then was hospitalized with toxic levels of oxycodone in his system. The petition brought by the department was that the child came within section 300B and G. What the mother was asked pursuant to these code sections is for the names of relatives. As you can see from what's up there, mother was a no-show at the arraignment and detention hearing, but had previously during interviews asked the maternal great aunt that she be assessed despite mother only knowing the maternal great aunt's maiden name. Mother also gave the social worker the name of maternal grandmother's, who was a legal guardian for another child. And the social worker went out and did her best to find the maternal great aunt using only a maiden name, and knowing that the paternal grandmother, who was the mother of the alleged father, might have some information. As it turned out, just using the last name of the aunt didn't do much good. The grandmother had left us on this plane of existence, and then mother's complaint on appeal was that due diligence by the social worker wasn't used to find relatives. The court said we can only expect the Department of Public Social Services worker to use the information that you give, and since you didn't give much good information, the worker did their best, and so we can't place with any relatives because we don't know where any relatives are. So the takeaway, I think, is that we want to, what we want to do is, from the very beginning of the case, get the names of some relatives, give them to the social workers who work in the court, let the judge know that you've given the names of relatives to the social workers who work in the court officers, and follow up. It's not always going to be easy, but that's, I think, what our job is to take action, because the court is only expecting the worker to do what they can, and we're going to have to do the rest. And that's the case of SK. Yes, Sue.
You know,
I got a question.
it seems that when there's a child that could be put up for adoption, the Triple P unit can find anyone. Has there been any case that has used that level of responsibility at this stage?
If that's the due diligence and you don't expect due diligence, to answer your question, I don't know of another case. I did look for them. But, then ask that that level of due diligence be used. There may be other persons to ask if you don't know, so it's still up to us to get that background information, to give the social worker information so that they can go out and locate relatives. Yes.
And I guess we would do the relative placement information sheet, even if the child is currently placed with the parent, just in case they are removed.
It's always, right? Yeah, it's always a good idea, especially on the worksheets that you have at the beginning. You want to get the names of phone numbers of other responsible relatives who may have landlines and the like, to make sure you have persons to call and to use to discover information about anybody else who may be available. You want, as we'll see in another case we're going to do, we want to get all the information we can about relatives at the very beginning of the case for ICPCs later and the like. Okay. All right. Okay, we can go on.
Pull up all the, his animation.
All right, I get to do WP as well. Let's see. This case was decided as a matter of law. The statute had to do with definitions of sibling groups under 361.5A1C and the brief description given for when judicial review hearings have to be heard under 366.21E3. That's when a child is under 3. When he's removed, you get the 6 months of reunification from dispo. And what the court did, as you can see up there, this case occurred in San Bernardino County. The CFS there detained the minors because of domestic violence and physical abuse, failure to provide, father's failure to reunify with siblings. By April, the court had sustained all the counts and gave mother family reunification, had denied reunification to all the alleged fathers. By the time of the 2-6 hearing in October, the mother had enrolled but then dropped out of a lot of programs. She was still testing positive for meth. She was homeless, and even right the day before the hearing, she admitted to using methamphetamines. What the court found is that for the purpose of the case, that only 6 months of reunification should be given to the mother for all of the children. The reason is because the court read the statute to say that all the children were removed from the same household so that all of the children, since one of them is under 3, all of the children are treated as if they're under 3 for purposes of providing family reunification services. What the appellate court said is that isn't true. 3 of the kids were all placed together in one home, which reflected that those children were placed together for the purposes, as the statute says, of placing and maintaining a sibling group together, even though the youngest and probably the cutest one was plucked out of the house and sent to the other foster home. As to that child, yes, there is 6 months, but for purposes of placement and maintaining a sibling group together, the 3 that were all placed together sort of count as another sibling group, since they were all over 3 years old when they came into the system. They're treated under 61.49, which is the date of entry into foster care. They get to go to the 12-month date. So even though the really cute kid may be placed in Lancaster while your client lives at the south end of the Crenshaw corridor, what you need to do is make sure that she has a couple other kids that can be placed together someplace, somewhere. And those kids will get 12 months, and sometimes you just have to give one away to get 2 back. Marlene.
Okay, because this has come up a million times where we have these sibling groups. So what you're saying is based on this case,
Yes.
where you have, they're always going to put the baby in a separate home to destroy the defense of the 2-6 of the sibling bond. But if you have a miracle where all the children are placed together, that's the part that's confusing to me. If the children are all placed together, is it 3 months? 6 months for all of them? Or do we then be able to say, it makes no, then what? So because you're saying if the kids are separated, it would be 12 months for the older kids.
Right.
Yeah.
What the Court of Appeal is saying, that as a matter of law, that when you read the language of the statute, it reflects that for purpose of placing and maintaining a sibling group together in a permanent home, should all other efforts fail, the sibling group, as it does under 361.5A and then B, determines how much reunification time it is. So if, in this case, the youngest was in a separate home with 3 others together, if they were all together, then you would be calculating the reunification time from 6 months from the disposition. And
When
then,
the court, at dispo, Steve,
Yes.
at dispo, let's do it this way. You're at Dispo, you got a baby in one foster home, you've got older kids in the other foster home. At Dispo, what does the court order?
It orders a 6-month review hearing, and it orders a 12-month review hearing. Okay, or at least sets the date. I think that we should all I think we all should have calculated the dates for the 6, 12, and 18 months at the time by the time we're at Dispo anyway. We all should do that. Remember, it's 6 months is 6 months from disposition. The 12-month date is set from the date of entry into foster care. What that means is that it is 60 days from the time of the original detention, so the detention plus 60, or the time jurisdictional hearing ends. That's whichever date is earlier. That's the date of entry into foster care. So even if you get 6 months from Dispo, the 12-month date is not going to be 12 months from Dispo. It's 12 months from the entry into foster care under 361.49. The 18-month date can never be more than 18 months from the original detention. There's some other rules if kids are returned HOP, and then there's, and that fails, and then there's another parent when the clock starts. But the basic calculation is that.
But if your court doesn't really go on that, you should bring it up and educate them on that. Because sometimes we have our 6-month date, and sometimes you know where it should be, so I'll keep my big mouth shut. And then every once in a while you get a county council when you're setting the 12-month. But in other words, if they don't know it, no harm, don't bring it up.
I don't know if it's always no harm. It's experience.
Well, sometimes you maybe.
Well, yeah, but also other times you end up trying to determine which standard, what's the standard. Is it clear and convincing, or is it preponderance that you're using at the JR? It's different from 12 to 18 months, and you have other exceptions at the 2-1 or the 6-month review hearing for children who are under 3 when they come in. You have to show by clear and convincing evidence the reasonable services were given. And if you have a parent who wants their kids back, they're going to follow the ASFA rules anyway that California's incorporated. You're not necessarily doing yourself any favors by just spreading this out as long as you can, unless the kids are older, and reach some milestone or something of developmental. Yes.
Now, if you have the same exact 4 kids, but they're all placed together at first, and then midway through the 2-1E, the youngest one gets moved to a different home, what happens with that?
I don't know. Okay, but that'll be the next year's Court of Appeal opinion. But I think if you read the statute, and you just have to figure out what the words of the statute mean. If the kids are separated out for that reason, just make your pitch that all the kids came in. Somebody's going to argue all the kids came in together. You're going to argue that, well, now that they're separated, the sibling group has been rearranged, so the older kids should get the additional time. We make this up as we go along, but it has to be within the reading of the statute as it exists. Any other questions? Okay.
All right, so in Ray TJV Superior Court, this is an intellectually disabled mother with an IQ below 70 who had her children removed from her for the standard reasons that a lot of mildly retarded parents do lose their kids. They are at functioning capacity, but they're not operating at full steam mentally. So, Steve is chuckling next to me. It's making me chuckle. But anyway, so this is a reasonable services case, and basically the bottom line here and the takeaway for you during your arguments, this case is very helpful to us for when it comes to providing access to reasonable services for mentally disabled parents. Okay. The Court of Appeal has held with this case that the court is authorized to extend reunification services beyond 18 months when it's clear that reasonable services have not been provided. The court has held in this case that the juvenile court has inherent authority to proceed with providing family reunification beyond the 18-month date as long as reasonable services are not being provided. That's number one. Number two, a great line here that I emboldened when I was preparing this is that there is no such thing as reunification light. Yes, they created a plan that was specifically tailored to this, this mentally delayed mother. However, the court held that access for her was not provided. The social workers did not do a good enough job of sitting down with her and actually connecting her to the programs. So this is the typical mental health mom, right? She's she's mildly retarded, and that's her diagnosis. She's difficult. She got into it with workers. She got into it with some of the service providers. They had a couple of meetings that didn't go well. But the Court of Appeal was more understanding than sometimes the judges in our courthouse are, right? They actually stated in their opinion that the nature of her mental diagnosis is what's contributing to her inability to comply. It was taking them a really long time, lots of months, to actually connect her with some of the services, and the Court of Appeal did find that that was not reasonable and that the agency should have done more. So the Court of Appeal did not have a beef or did not have a problem with the actual way that the plan was tailored. They had a problem with the fact that the social worker was not connecting the mom to the services, or giving her referrals. And what really helped this mom, and what kept the Court of Appeal from finding that this mom was difficult, she didn't do as much as she could have done. They said that she did show a willingness to participate in the programming. However, the social workers did not meet her halfway. So this is really helpful for us, not only when it comes to mental health cases, but also reasonable services cases, and asking the court, if necessary, to go beyond the 18 months when our mental health clients, especially for mental health clients who have indicated a willingness to comply. There doesn't have to be, even if there's not a substantial probability of return, we still can make this argument and use this case, and it's in our favor.
What was the next hearing called?
Her services were terminated. What do you mean what was the next hearing? Because this was a writ from the setting of a 2-6, and her services were terminated at the 2-1F.
So they gave her to a 2-2?
It can go beyond the 18 months is what it specifically says. So beyond 18 months to the 2-2.
So would it
when
be
reasonable services are not being provided.
Would it be a continued 2-2? Did they call it a 2-5? What did they?
I don't recall them calling it. I don't recall them calling it a 2-5. So, and I don't want to guess.
It can't be a 2-5.
She doesn't meet the point. I don't think that it wouldn't be a 2-5 because it's not meeting the requirements of pursuant to 2-2B. So it would not be a 2-5.
Oh no. Okay, in Ray JH, this is not news to you, right? Parents do not have a right to cross-examine the social worker who authored the status review report at a contested status review hearing. So I mean, I've asked for the worker over and over. You know, they're not. They moved on. They're not employed by DCFS anymore. But guess what? The supervisor is available. The supervisor will come in and testify. So here's this case. The Court of Appeal wants to make it clear. This is not a point of debate when you guys are setting up your contest. Why? Well, before we get to this whole Sixth Amendment right to confrontation, in the Welfare and Institutions Code, it is a closed universe to a certain extent. There's certain other parts of California law that dovetail within it. But it's closed universe, and contained in the Welfare and Institutions Code are the evidence rules. And as you know, we're dealing with dependents, with children. So the rules are set up to allow as much information as possible in order for our courts to be able to make the best decision on behalf of these children. So circling back to whether or not you have a right to cross-examine the social worker who actually authored the report. No, you don't. The report comes in. It's in. If you want to debate or challenge some of the information that is contained in that report, find some witnesses. Put your client up there. Find someone else to put up there and challenge that information. But the report is in, and the supervisor can come on in, assuming the supervisor has supervised that person, is familiar with the case, and especially if that person goes up there and you start to question them, you can't raise an issue for the appellate court to start looking at. So going back to your right to confrontation, do you have that right? Yes, of course. Do you have it the way criminal defense lawyers have it? No, you don't. This is a completely separate area of law. So in juvenile dependency litigation, due process focuses on the right to notice and the right to be heard. A parent has a due process right to confront and cross-examine witnesses, but all that is required is that the procedure adopted comport with fundamental principles of fairness and decency. And that, of course, is up to your bench officer. It's fair, decent. And that is what we have to deal with every day. And so here again, these admissible or these exceptions to hearsay, they're all throughout the Welfare Institutions Code. We see it at 355, we see it in 358. So if you start reading the code and you see a little sentence or two about the kind of evidence that's allowed in, that's it. There's nothing more. And so if you want to kind of recall some of the things that you learned in law school or what your colleagues in other courtrooms are doing, meaning outside of dependency, if they're downtown in civil or over at criminal, it's not going to work. It's not going to work. So you've got to really dig down in your toolbox and find a way to defend this client without starting to go after whether or not the social worker who authored the report is available. It's not going to work.
Elizabeth M., this actually was my case in Judge Silas' court. So this was terminated TPR, and there were 4 kids, and I represented the father. Both parents filed an appeal from the termination of parental rights. There were 2 boys placed in one home, 2 girls placed in another home. I don't know if Danielle Stahura from LADL 1 is here, but she and I did this case together, and basically we were asking for a continuance to see if, and we also argued for a sibling exception to TPR, which didn't work, and the Court of Appeal upheld Zeidler on that. It was reversed and remanded as to ICWA because mom claimed that she had Indian ancestry. She red tails. That's what she said. She said that she was red tail. And even though that is not I've never heard of the red tail, and Zeidler hadn't heard, nobody had heard of that. You've probably never heard of it. However, if they put it down, there has to be a reasonable inquiry, and they didn't inquire. So it was sent back for Zeidler to order them to at least follow up on what had been reported, and for them to make the inquiry, at least ask some relatives, which they did not bother to do. And so that is one of the takeaways, is that no matter how preposterous whatever the parent is putting down on the ICWA notification form, DCFS in the court still has to follow up on it and ask relatives, ask the parents, and try to follow up. Also, when it comes to the sibling relationship exception to TPR, the children, yes, they lived together and they were even returned to their mother at one point, but then they got removed. They had not, at the time of TPR for the girls were in an adoptable home, the boys were not, and the boys had behavioral issues. The parents wanted a continuance to see if all the children could be placed together with relatives down in Texas, and Zeidler did not believe that these children who were all very young, they were all under the age of 10, they had not lived in the same home in the last 16 months prior to TPR. Zeidler did not think that the possibility that they might be placed together, and they didn't see each other that often. They had visits ever so often, but he didn't think that the sibling relationship was strong enough. It wasn't there, and those were some of the considerations that those were some of the considerations that he made. The nature and quality of the relationship, it did not outweigh the permanency that the girls could get. So he did not grant the continuance to investigate placement of all the children together, and the Court of Appeal upheld him on that. And when as it concerns continuances at the 2-6, no continuance shall be granted that is contrary to the minor's interest. So there was a possibility that the kids might be placed with a relative, but Zeidler was not obligated to wait around for what the Court of Appeal called a hypothetical possibility. So he was right to deny the continuance request, and the Court of Appeal agreed with that.
MH. Okay, that too is my case I reviewed. This has to do with relative preference and foster caretaker placement. Two statutes again involve the relative preference under 361.3 and the caretaker placement preference when the caretaker wishes to have a permanent plan with the minor, and that's found in 366.26K. So those are the two statutes at play. What happened here is that in April of 2016, there was an arraignment detention. It was positive tox baby was placed in foster care. Sometime around July 2016, a maternal great aunt from Minnesota came forth and initiated an ICPC. There were only a few visits. I think there were 6 total in this case, where the aunt had come out to California to visit with the child who was only in the same foster caregiver's home. By February or so, there was a contested 2NE. The foster caregiver then was willing to provide a permanent placement for the child. Mother's family reunification services were terminated. As it turned out, the maternal great aunt was then approved for placement. The minor's counsel objected, and the 2-6 was set for a contest. The court ended up granting the foster caregiver's de facto parent status request, and the recommendation from the department was for placement of the child with the maternal great aunt in Minnesota, and the question up on appeal was, well, what to do? One thing we need to know about the 361.3 preferential consideration for relatives, it's available. A relative has a first shot at getting the child placed with them at the time of the initial placement. After disposition, the relative placement preferences, first opportunity for placement, but only if the child is going to be moved. So again, as to the last case I discussed with you, get the names in early. Okay, we seem to think, at least a lot of what I've read, is that the relative gets the first shot every time. That's not how the statute works, and it's not been interpreted that way either. It's a first preference for the first placement, and then between dispo and termination of family reunification, it's the first chance for placement if the child is going to be moved, or after reunification services have been terminated before the 2-6, if the child is going to be replaced. That's the relative placement preference. Okay. In this case, it didn't seem to matter anyway, because the maternal great aunt at the time of the hearing, even though which was before the January 1st of this year, didn't qualify as a relative placement for preference. Anyway, the statute, as you know, now reads great aunt, great grandparent, great uncle. It didn't before January 1st of this year. So I know everyone looks at the statute that talks about 5th degree. That's the specific placement statute for preference. it didn't use that language until this year. So the maternal great aunt wouldn't have qualified for relative placement anyway. The other thing is that you have to look for the best interest. In this particular case, we had a child who was African American, was placed with a white family, but the child was described as being very happy, doing really well, had friends and family and all. And the social worker who testified at the 2-6 was saying that, you know, the preference as he saw it was that the child be placed with family and in my culture. They came up with some, I don't know why, but they always discuss how much fun it is to play with toys and get books on your cultural heritage, and that's going to be the same thing, but that's what was discussed here as well. But because it was deemed to be in the best interest of the child to stay where placed, the child stayed with a foster caregiver. And when you look at 366.26K, it's talking about who has the preference for adoption between a relative placement and the foster caregiver. They say whoever the child is placed with has first shot at getting the permanent placement. So that's what this case stands for. It's sometimes, at least I've seen it in some reviews, as relative preference versus caretaker placement. But again, there was no relative preference because of the degree of separation at the time the case was heard under the statute as it then was reading. Any questions? Okay.
Okay, so this is in re CA. It speaks of the application of ICWA. So you are you're next for pickup on the ready board, or at least on the party's appearance board. You see mom, you see MO, FA, and then you see BF. Okay, it's the boyfriend. Okay, so he's out there, and there's this discussion amongst your colleagues, who's going to pick up the boyfriend? Do we pick up the boyfriend? I mean, he's not even the father. Okay, turns out, you know, he wants custody. He wants custody. All right, let's give this guy a shot. So you pick up the boyfriend. You're sitting down with the boyfriend. You're getting all of the detention paperwork, getting that started, right? You have to go through all these different copies. You get to the ICWA 20. You're filling it out, yeah, for the boyfriend? You guys are filling it out for these non-biological persons who want to be found presumed. Filling out the ICWA 20, yeah, he's got a Native American ancestry. You turn it on it. Okay, you go through the whole dependency proceedings. You get to a point where the guy is found presumed because he eventually marries the mom. Hey, he's not the biological father, but he does get elevated to presumed. Long story short, he does not reunify. Parental rights are terminated. ICWA, what about notice? Did they send out the right notices for this guy? Okay, but no, he is not the biological father. And even though as the presumed father, he has a right to ask for custody of this child, ICWA is written by the feds, okay? And it is strictly construed. A presumed parent status does not trigger ICWA notice if the parent is neither the child's biological or adoptive parent. So typically these issues are popping up when the case is going on appeal, even if you haven't necessarily raised these issues about ICWA notice. They can be caught because you can't ever waive ICWA. Ms. Burke.
If the adoptive parents are registered members of the tribe, does that trigger ICWA? They're adoptive parents, but they are registered members. So the child may not biologically be an American Indian, but through their adoptive parents, does that trigger it?
If they are neither the child's biological or adoptive parent, then it doesn't apply. So if they are the adoptive parent, then it's going to work, right?
Well, that was my, like if,
yeah.
Like when sometimes we get cases where we're representing the adoptive parent.
Right.
So if they're the adoptive parent and the biologic, we don't have to worry about the biological. I'm a little confused, if you run that.
Okay, so let's just rephrase it. If you are in no way legally related, legally being because you are the biological father
Right.
or biological parent,
Right.
or you're the adoptive parent, the law recognizes you. If you're neither of those two things, ICWA will not be triggered.
Okay.
Yeah. Okay, and then there's a little other small piece to this particular case. So, mom brings boyfriend, to have him elevated to presume. There's this biological father too, right? He's there. So he also makes an appearance. He fills out his ICWA 20, and he says, I think I do. And so, of course, the court asks for the department to go into a further investigation. Okay, somewhere down the line, he says, oh no, I don't have it. That's done. So mom, at the end of this whole thing, she can't then say, well, what about ICWA notice as to the biological father? No, once you disavow it, it's done. Can't go back. Sophia M.
Okay, Sophia M. is a pretty good case. It's something that comes up a lot for us in the practice of independency. The opening line of the case is, we have encountered this narrative before. Mother makes no progress on her case plan for a whole year. Then when it finally sinks in, she's going to lose her parental rights. She begins eagerly complying with the plan. The twist in this case is that the child, Sophia, was 14 years old, and by the time mother decided to comply with the plan, Sophia was depressed and too hurt to want to spend any time with her mother. What this case points out, and I'll get into that, is that you're weighing facts on the scale between the parent having regularly attended, at least in the last few months, and completed or made substantive progress in counseling. It's not going to erase not doing anything for a year. In most cases, if the child has developed some aversion to meeting with the parent at visits or demanding a limitation on the visits, especially an older child. In this case, mother had abused drugs. She had failed to visit the child regularly. Then, in the last few months, became active in parenting classes. In the meantime, she would fail to meet the child for visits at scheduled times. The child would be happy in anticipation of having her mother visit, but then would become depressed and start crying when she realized her mother wasn't going to come. Then she ended up not wanting to see mother at all. When the child refuses visitation, it's the parent's burden, the Court of Appeals said, to request a specific type of enforcement. Mother was complaining on appeal that the court hadn't enforced its own visitation order. The court said we can only do so much. We made the order. If it's not being carried out in the way the parent wants it carried out, the trial court's job is not to make tweaks to the visitation plan. It's the parent's job to come back to court and make recommendations for how this visitation plan may be effectuated more easily than it had been in the past. So we have to be more proactive representing our clients who aren't visiting regularly or having the interaction with the children that we think they should. So there was no abuse in discretion because the trial court was only required to make proper visitation orders, not to enforce them. When a child refuses visitation, it's the parent's burden to request a specific type of enforcement or request a specific change to the visitation order. Absent a request, the court has no sua sponte obligation to make changes. Don't wait until the next JR because it might be too late. So walk the case on. It's not a 385, by the way, but walk the case on to bring it to the court's attention that visitation isn't going as well as it should be, because that's such a key part to making any pitch for reunification. That's probably the only place a parent can say, I've gone to counseling, I've learned a lot, and this is how I applied it during the meeting with the child. Okay, that's pretty much what the case stands for.
Okay. So this case, in Ray, Christian K, I think is super significant for us parents' attorneys. I'm going to just put a proviso out there. The particular facts of this case have to do with reasonable services after the reunification period has ended. And in this particular case, just so that you can distinguish it, the parental rights were also in limbo. The mother's parental rights were terminated, but then she appealed, and the Court of Appeal was reviewing that. So I just want to say, typically for us, when we are considering services and whether or not they're reasonable after the reunification period has ended, it's because our client has filed a 388. The court has granted further efforts or further services. Here is a case to read concerning whether or not you as parents' attorneys can argue and challenge whether or not your client got reasonable services during this portion. Services are treated differently by statute at different stages. Section 366.3, that's the statute that applies when you guys have a client that is getting services pursuant to a 388. Does not mandate a particular consequence if adequate services are not provided. Because no consequence is mandated for the failure to provide reasonable services, the statute confers discretion upon the court to issue any appropriate order, including setting that 2-6 again. Think about it, you guys. You guys are really trying to advocate for this client. They've got these services. It's pursuant to a 388. You're going to try to go for the no reasonable services argument. Think again. May not be available to you. Somebody might say, well, this case really talks about something different because the mother's rights were terminated. I'm going to say, look at this case and consider that you don't have a reasonable services argument when your client is getting services pursuant to a 388. Oh, in Ray KR, another ICWA related case. Oh, okay. So this is the one when you guys are going through the ICWA notices and you look to see whether or not those, you know, the notices are filled out, the mother's side, the father's side. When you start seeing blanks or the words unknown, you've got to raise the objection to the ICWA notices. They are not complete. So the court cannot make a finding that ICWA either does or doesn't apply because the notices are not complete. So the juvenile court, so usually what happens is the Court of Appeal, or the Department of Children and Family Services, we like the court to make a no ICWA finding. The notices are attached, and everybody just kind of goes along with it. The court rubber stamps it. You guys are not doing that. You guys are looking through. You got it all dog-eared at the back, and you're seeing whether or not it's properly filled out. The juvenile court cannot assume that because some information was obtained and relayed to the relevant tribes that the Social Services Agency necessarily complied fully with its obligations. The court has a responsibility to ascertain that the agency has conducted an adequate investigation and cannot simply sign off on the notices as legally adequate without doing so. In this particular case, when you get a chance to read it, you'll see some facts were obtained, but not all the facts that could have been obtained were obtained. The social worker had more information that he or she could have called and investigated further, and they didn't. Notices were not complete.
Daniela G, unavailability of child testifying at jurisdiction disposition. So basically, in a nutshell, bottom line here is parents do not have an unfettered right to cross-examine children and call them to testify, especially in sex abuse cases. If I were to recommend reading any of the cases that I've presented on, it would definitely be this case. We can't just assume when we're setting a case, especially our sex abuse cases, for trial. We cannot just take it for granted any longer that we're automatically going to have a right to bring the child in to testify. In Daniela G, the father did not offer the option of the child test. The father made some mistakes here at this trial. One of them was he did not ask for the child to testify in chambers. He didn't make that request until he got to the Court of Appeal level, and the Court of Appeal said you didn't make that request at the trial level, and therefore that request has been waived. So even if the testimony that you think is going to be relevant from the child, even if it's relevant, even if the child is competent to testify, even if the child is practically and legally available, the juvenile court has discretion to refuse to require a child to testify if the testimony would, if the benefit of the testimony would not outweigh the psychological injury that could happen to the child. The Court of Appeal found that the objective of dependency hearings is best interest of the child, and it is a perversion of the procedure to require that the child's testimony is always presented regardless of the trauma to the child, regardless of the necessity of such testimony. Father also argued that an expert was required to say that there would be psychological harm to the child, and the Court of Appeal disagreed. There does not have to be expert testimony of psychological injury to the child. If a therapist for the child, if the social worker, if somebody said, if the child is self-harming or scratching or biting or making yourself bleed or whatever, if there's some indication that, that there's psychological stuff going on with the kid, expect minors counsel to make a request that the child not be required to testify. And when you do pull up Daniela G, there are ways to defeat this. And one of those ways is to dispute everything, because the court specifically says that one of the considerations is whether or not there is a material issue that's in dispute that would be affected by the child's testimony. So don't let any issues go. Don't stipulate to anything. This guy did not dispute the fact that his daughter said that she had to give him massages. He didn't dispute that. So because it's not in dispute, why do you need her to testify? She talked about it in the reports. So if there are issues in dispute, then it's your job to pull those out and bring them out to the court's attention. Colony is another ICWA case, and basically it talks about the section of C1B exceptions. We never look at those because we rarely ever do ICWA termination of parental rights, but it's about C2B2 exception. It requires proof beyond a reasonable doubt that continued custody would likely result in serious there will be a likelihood of serious emotional damage if continued custody remains with the parents. It defines what continued custody is because father disputed that, and it also requires a much higher showing from the department, proof beyond a reasonable doubt. It would be nice if that was required for all of our parents, but it's specifically applicable in ICWA cases.
So 2 more cases? Okay, in Ray, so on the same topic of termination of parental rights, this case is great for us when we're trying to come up with a defense, but the specific thing about this particular case in Ray JW is to know the distinction between a child that is generally adoptable and a child that is specifically adoptable. When a child is specifically adoptable, that's because there is a caretaker who steps up and waves their hand and says, I will adopt this child. When that happens, you may have an issue to raise in defense of your client with regards to whether or not this child should be adopted. If the child is deemed adoptable, based solely on the fact that a particular family is willing to adopt, the trial court must consider whether the prospective adoptive parents can meet the child's needs. So you can dig deep into the actual caregiver if that is the case. This is the case that you want to review.
And lastly, in Ray DB had a 6-year-old sibling who suffered serious injury as the result of his parents' routine practice of hitting him with a belt. The kid showed up at school one day with blood seeping through his pants where the parents had beaten him with a belt. What happened here is that the court was looking at a 300J which was filed as to the 2-year-old sibling. The parents' challenge was that 300J did not apply to a court's finding for removal of DB from the parents under 361C1 on grounds of emotional abuse, when emotional abuse, only subdivision A, was found as the reason for removal under 361C1. The parents said that looking at J, it doesn't include subdivision C as a reason for application of that statute. The Court of Appeal went way out of its way, and I think not very reasonably, in my opinion, found that it looked at the totality of the circumstances of abuse, of how the neglect occurred, the age and gender of the child, the nature of the abuse, the mentality of the parent, what did they learn in counseling. The court here found that the parents hadn't quite learned enough or didn't show that they really understood what was going on. They found that the child did, by suffering abuse as it would be described under C, met the totality of the circumstances test, looking at or borrowing from a sexual abuse case, IJ, decided that the risk to the child, even though low in probability, if what happened to his older brother happened to him, would result in great harm. That was what meant 361C1's requirement for removal due to potential physical or risk of physical harm to the child. They kind of went out of their way to look for a C, reasons for the C to remove, even though C was not found to be one of the causes. So you look at the totality of the circumstances, it's all to protect children, according to the court, no matter what the law spells out as far as subdivisions. But it's an interesting case to see how the court reasoned. And that's it. I hope you had a good time. Party down.